shall say.
Okay, so welcome to another First Friday from the Franchise Company. We are always delighted to host these events, and we're getting lots of great feedback from people who are visiting, returning visitors, first-time visitors, etc. Because what we try to achieve is a mix between an opportunity to educate and share knowledge, but also to hopefully create an environment where people are inspired by the quality of the speakers that we can attract. Now, what I would say about that is today we have a legend amongst us who is going to speak to us. He's looking around to see who I'm speaking about, but for those who don't know, John Pratt is a legend in the franchise sector, and he's going to hopefully give us some insights into kind of how to protect the business from the nasties of things like litigation and those kind of areas, because it's really about sharing some of those experiences and, you know, helping those on the call to be safe, sensible and prepared. So without further ado, John, I would be delighted to hand over the reins to you and thank you for agreeing to be our guest today. You can see by the numbers on the call how much of a legend, how popular you are. It's a very good, well-attended call. So thank you, John.
Well, Nick, thank you very, very much for that far too generous introduction. It's bound to be a disappointment after that, so I apologise in advance. It's a real treat to be here. As Julie knows, I can't refuse any request from her, and or indeed from the franchise company, who are magical franchise consultants. They combine being nice, being concerned, with vast amount of knowledge, and really get to know their clients. So I am a huge admirer of the franchise companies. Thank you very much for asking. Now, what this, and before we start the session, why I haven't got any PowerPoints is that I want it to be slightly less formal than that. And with PowerPoints, you sort of take away that personal touch. And to encourage, if you want, you don't have to sort of questions during the session, you raising points, you telling me I'm talking rubbish, haven't explained something properly. You do all of those things, and I'd be delighted. Although, as I said, please don't feel obliged to, to raise anything. And the problem with PowerPoints is that it makes that more difficult. So I hope you've all got the notes that I sent to Julie, and which should have been sent to you. You may need to sort of keep an eye on those notes to work out where we are. Basically, this session is going to be in two parts. First of all, I'm going to try to explain to you why I think litigation is a seriously bad way of resolving disputes. Now, if in this first part I haven't actually persuaded you that litigation is a bad idea, you might want to skip the second part, which is what you can do to avoid litigation. But I will give it my best shot to persuade you why litigation is a bad idea. Now, just to be clear, I am not saying that litigation should never be used. I can see some situations where, unfortunately, litigation has to be used. For instance, you have an ex-franchisee who's terminated and is still using your brand. Now, that is probably something you simply can't allow to continue. And if your ex-franchisee doesn't see sense, I have to do something about it. I can't, in all honesty, think of too many other situations where litigation is going to be your best bet. Now, this won't be much fun, because trying to make a talk about legal aspects of franchising fun is beyond my capabilities. But it's really important, and it's really important because all of you involved in franchising are almost bound, well, forget the almost, you're bound to have a dispute with your franchisees. franchising is really heavy on disputes, however brilliant you are as a franchisor. And the reason for that is that generally franchise agreements last for 5, 10 plus years. So they're very long-term agreements. They tend to be very detailed with lots of obligations and restrictions on your franchisees. And in the franchise relationship, in the early days, as we all know, franchisees are enormously grateful for everything you're telling them and, you know, all the guidance and help you're giving them. And they don't mind paying you the continuing fees and the management service fee. But then as it goes on, not to resent, thank you, they start to resent it, and that causes friction. So you're in a business which I think is fabulous, area of business which is fabulous, but is open to disputes. So what is the theme have I got for part 1 of this session, which is why litigation is such bad news? Well, it's bad news because the outcome of litigation is never certain. A case you can't lose in any form of litigation, you only have an 80% chance or 70% chance of winning. Now, that sounds pretty good, but actually, if you flip it, in a case you can't lose, 2 or 3 times out of 10, you will lose. And this is a case you can't lose. And let me tell you, most cases are not cases you can't lose. Most cases are, you know, 50, 60, 65% in your favor. Now, every law firm I've ever come across will always say to you, yeah, those statistics are right. But of course, our statistics are much better than that. Well, there must be an awful lot of law firms that lose every single case, if that is indeed the position. You need to bear that statistic very much in mind. And we're going to be talking about the Drain Doctor case. And again, you should have notes for the Drain Doctor case, because that was a case that the franchisor and its legal team could not lose. Absolutely, they couldn't lose, and they lost. And we'll explore some of the reasons why that can happen. I'm not in any way criticizing the franchisor or the legal team. It's one of those things about litigation. So don't assume that litigation will come to the right answer. Now, there are 2 things I want to say about the process of litigation. First of all, we have a weird process in the UK. It's a common law principle. And because, and this is, sorry, going back into history, because we have proper functioning courts that weren't, courts set up by the local lord of the manor, but were set up by the king, we had courts way before they did in Europe. The problem in the early Middle Ages was that nobody or very few people could read or write. So we have this oral tradition of lawyers presenting the case orally in court, which they don't have in the rest of Europe. Now that makes cases very long, and in most commercial cases, a complete waste of time, or the cross-examination that barristers want to do, because I've never, ever come across in a case a barrister's cross-examination really having any material effect. But it substantially increases the cost of litigation, and I'll come back to the cost. But then if you think about it, if you had to devise the worst possible system for resolving a dispute, I think it would be litigation, because the person who knows the most about the dispute will be your client. The second person along the line, the solicitor, will know the next most. The barrister who's going to present the case in court will know less than the solicitor. And the guy or guy-ess who knows the least about the case is the judge, and he's the one that's going to make the decision. And if you throw into the mix that it's the franchisor or the franchisee that knows the most about franchising, maybe not the legal aspects, but the most about franchising, then it's the solicitor, because usually you're going to be using solicitors who know and specialize in franchising. Then the barrister, and generally barristers don't specialize. They may do a bit of franchising, but they don't specialize in franchising. And then the judge, who may know absolutely nothing about franchising. So it is a complete recipe for coming to the wrong decision. The second bit is that it's really difficult to predict the approach of the judge. We're going to see, when we look at the Drain Doctor case, a judge approaching it in a particular way. And it was a particularly pro-franchisee way. And we see that on occasions. There's another case called Papa John's, where again, the judge was tremendously supportive of the franchisee, who was a woman with no business experience, from an ethnic minority, deeply religious, who devoted a lot of her life to charitable good works. So, you know, the franchisee from hell, if you like, in terms of a case against them. Now, some judges take those considerations very much into account. Other judges just don't. They just look at the law. And unlike in those American TV series where you can get to pick your judges or whatever it is, you can't pick your judges in the UK. So you don't know before the case what sort of approach it's going to take. Next, lawyers love litigation. Okay, why do we love litigation? Because we make shed loads of dosh out of it. And in a sense, it's an advertisement for us. Look, we've been involved in all of the latest big cases in franchising. That's how much we're in demand, how clever we are. Now, neither of those two are good reasons for you to litigate a dispute. I'm going to ask you a question, if I may, and this will be the last question, the first and last question I'm going to ask you. So don't be nervous about, oh God, is this bloke going to be asking me loads of stupid questions? How much do you think a 5-day franchise trial in the High Court would cost? And 5 days is quite normal. Now, have a figure in your head. If you were to use a firm like ours, and I hope you're all sitting down, and it looks to me as if you're all sitting down, it would cost about £250,000, £250,000. If you were to use a large firm in London, those costs could be £500,000–600,000. If you were to lose the case, you would have to pay 60% of the other party's costs. Usually, it can vary. So a case could come to anything between £500,000 and £1 million. Now, if you're McDonald's, yeah, you can afford it. But most franchises simply could not afford that. And so I've always said that the only thing that could completely destroy your business is litigation. It certainly is something that could destroy your business. I think we probably need to add pandemics as well as litigation. And that's why it's very important. Ken, you got a question?
No.
Oh, sorry, you were just flashing in the sense of, you know, the thing around your picture was flashing, not in,
all right,
in any other sense.
Must be a halo, John.
Oh, well, there you are, Ken. What a good human being you are. Okay. In addition, you throw in the stress, you throw in the management time. But what about all this guff about sending a message? I have heard this lots of times, that, oh, you've got to litigate to send a message to the network. Well, let me tell you that, number one, if you think the best way of communicating with your network is to litigate, then you've got something very, very seriously wrong. Number two, in my experience, if you win, it doesn't send any message to the network, because you might still have unhappy franchisees who will always think their case is different. But if you lose, it will send a message to the network. And the real risk in franchising, apart from all the costs and the other things that we've just been talking about, is that if you lose, then other franchisees who are unhappy might say, hey, well, we can terminate, we can do whatever bad thing it was that the case was all about. So you're taking a really big risk. And finally, in terms of, well, not finally, in terms of the disadvantages of litigation, Nigel Topless, who was a past chair of the BFA, British Franchise Association, said to me, John, you've only given me one bit of useful advice, and that is never litigate. Well, hold on, Nigel. I've actually given you shed loads of really good advice, but it was probably the best bit of advice I ever gave him. So just in case you were thinking this was getting way too interesting, let's bring it down to something really no, that was a joke. Obviously, you weren't. Let's have a look at this famous drain doctor case, which is a case that came out only a few months ago. And you probably need your notes for it. I've set out very much in summary the salient facts. Drain Doctor was part of Neighborly Group, a huge American franchisor with Mr. Electric, loads and loads of other brands. The franchise agreement was prepared by a lawyer I know well in a large London firm, was over 100 pages long. I know his franchise agreements. They are utterly, utterly unacceptable in terms of being one-sided. And the judge really, really didn't like the franchise agreement. I think there's a clue there that actually preparing an appropriate franchise agreement, rather than an agreement that protects you from invasions from Mars, is a really good idea. Always prepare an agreement with a view to how would it appeal or not appeal to a judge. Well, this franchise agreement really, really did not appeal to the judge. The franchisee in this case terminated the franchise. He claimed that the franchisor had done something wrong and he was entitled to terminate. The court didn't agree with that. He raised all the standard arguments about misrepresentation, breach of contract, as well as some non-standard but increasingly common arguments that he was forced to enter into the franchise agreement, wasn't given enough time, and so on. The judge said, no, I'm sorry, all those arguments are wrong. The franchisor said, right, this guy's continuing to trade, rodding drains and doing all the other things that Drain Doctor does. He owes us money and he would have paid us continuing fees had he not unlawfully terminated. The non-compete covenant was, as we'll see, as you can see in the note, I won't go through it, was the sort of covenant you would expect to be fully enforceable. A covenant that basically lasts 12 months, operates in the franchisee's territory. There was a bit that says it was 5 miles outside the territory, which was never going to be enforceable, but that didn't matter. And so the franchisor launched proceedings. Now, why did the franchisor launch proceedings? This was a franchisee that had failed. he was a useless franchisee. I'm not blaming him. He just wasn't any good at it. So what was the point? And let me add, he was a franchisee, he had no money. So what was the point of bringing a claim against this franchisee? Well, let me tell you, there was absolutely no point. And of course, the franchisor lost. Now, they are appealing the decision, and the appeal is going to be heard in May of next year. And I think there is a good prospect that the appeal will be successful, because the judge took a completely pro-franchisee line, said that, as I've already indicated, I really don't like this franchise agreement, number one. Number two, the franchisor took no account of the fact that the franchisee was inexperienced in business and didn't know anything about the business of the franchise. Now, that's a worrying one, because inherently in franchising, you pick franchisees who don't know about your business. You don't want them to come with any preconceived ideas. The franchisor didn't treat the franchisee compassionately. And I think that bit is certainly right. But the bit that really upset the judge was that if Drain Doctor, Neighbourly Group, was successful, effectively this guy with his partner and their children will be out of their home. And the judge said that in effect, I don't think that's right. And so he was at pains to find reasons why the post-termination non-compete covenant was unenforceable. And he found loads of reasons, a mixture of good reasons and actually really, really bad reasons. So it's going to be interesting to see what happens in the Court of Appeal. I think they will win, not on everything, but they will win. But hold on, it will have cost them £400,000 or 500,000. I don't know, vast amount of money to win. They're not going to get any of it back because the franchisee hasn't got any money. And they would have been so much better off not bringing the action, but just competing with the franchisee, approaching the existing customers, offering them discounted rates, doing a really heavy advertising campaign in the franchisee's territory. And there's the plus of that is it would be a hell of a lot less expensive than paying lawyers, and it would benefit the bottom line because you're increasing turnover on which continuing fees are paid. So the Drain Doctor, a case that the franchisor could not lose, lost. It's a case that the franchisor should never have brought, because the answer was don't bring litigation, but instead just compete heavily with the franchisee. And it's a case that, frankly, none of the franchisees gave a monkey's about. He was some guy in Cardiff who wasn't very good. They didn't give a stuff about what the franchisor did. So that's why I think litigation should always be the last option. It may not be an option you can wholly disregard. And certainly you would never announce to your franchise network, don't worry, guys, we're never going to litigate. I mean, obviously, when there is a dispute and at an appropriate time, indicating that you would litigate and go to court is quite a valuable strategy. But actually following through is something I think you need to think very, very long and hard about. Now, what do you do about it? Assuming that so far I haven't completely lost you and you think, well, what a Burke. Well, you may think what a Burke, but providing you agree that litigation is a seriously bad idea, what can you do about it? Well, you don't leave it until the dispute arises and you've got to decide whether to litigate. That is too late. So with your permission, I'm going to take you on a journey of the stuff that you really need to do in order to put yourself in the best possible position not to go to court. Before I do that, just let me tell you that what happens in practice is that if you've got a problem with a franchisee, and let's just say you've got a dispute, the franchisee isn't paying you. So you get sick of the franchisee, you terminate, and you bring what on the face of it is a dead simple debt recovery claim. Judge, this franchisee hasn't paid me the continuing fee for the last 4 months. It comes to 18,643, get him to pay up. Dead simple, contract there says he's got to pay it. What could be easier? Well, what happens is that the franchisee goes off and sees a solicitor, and the solicitor says, oh, hold on. Has the franchisor performed all of its obligations under the franchise agreement? Oh, no. Okay. Breach of contract claim. So we'll counterclaim. And did the franchisor give you a load of information, particularly financial information like projections, like startup costs, like how much money you can make to encourage you to enter into the franchise agreement? Oh, we did. And you didn't achieve those. Oh, okay, well, we'll throw in misrepresentation. And so what happens is a very simple case against a franchisee for payment of fees turns into a mouth-wateringly complex case where the lawyers make shed loads of money. Now, I'm a lawyer and I love making shed loads of money. And if any of you here love lawyers so much that you want your lawyer to make shed loads of money, I would really, really like to act for you. But assuming that you don't fall into that very exclusive and elite category of franchisor, think long and hard. Now, right at the beginning of the journey, what should you do? Well, I'm very keen on providing a very short and simple disclosure document. For those of you who are members of the BFA, it's a requirement of your membership to provide a disclosure document, which sets out information about the people involved in your company, details about franchisees, another thing. Dead simple to do. It's 3 or 4 or 5 pages. It's not only in compliance with the requirements of the BFA, but actually it's helpful in showing that you've done it properly and you've given information to a franchisee. You need to make sure, obviously, that the information in that disclosure document is true, but you need to do that. Even if you don't want to prepare a document, one brilliant and futuristic franchisor was foolish enough to decide that it wanted to present its agreement not in, to explain its agreement, not in written form, but by way of a video. And PGH Begon stupidly got me to do the video about the agreement and things to look out for in the agreement, because one of the things you're supposed to do is to highlight to prospective franchisees any unusual or onerous provisions in the franchise agreement. Now, Caroline is watching this. I suspect my video has meant you've recruited absolutely no franchisees who've watched the video. I hope it hasn't been too much of a disaster, Caroline, but providing you get somebody good, not me, to do the video, I think it's a neat idea. You can highlight those provisions which are unusual and onerous, which is what you're supposed to do, and is not too formal and legalistic. Next, you need to think about projections and business plans. Most franchisors provide projections and business plans. There is nothing inherently wrong in doing that, but let me tell you that the huge majority of misrepresentation claims relate to financial information like projections and business plans. So you need to be super, super careful about what you put into those projections and business plans. There is only one way you can protect yourself from a misrepresentation claim in respect of them, and that is to make sure that everything in the projections and plans is true. And what do I mean by true? I mean that it depends, they're based on the average performance of franchisees, not the performance of the 10 best franchisees, but even the crummy ones as well. So the average performance. Now, if you're at an early stage of development, you may not have enough franchisees, and you need to say, look, we haven't got franchisees. We've operated a pilot operation. It's based on that. So that's the first thing you need to do. Of course, you need to put in properly prepared disclaimers saying the basis on which the financial information was prepared, saying it's not guaranteed, saying that franchisees need to produce their own figures based on the advice they receive from their own advisors. And that disclaimer, and franchisors hate this when I say it, that disclaimer needs to be in big, bold, ideally, red on the projections. Whilst you may hate it, in my experience, it makes no difference, okay? It doesn't, no prospective franchisee has ever said, I'm not going to enter into this franchise agreement because of the disclaimer on the agreement, on the projections. Next, you need to have proper provisions in your franchise agreement, but you will never be able to protect yourself from fraudulent misrepresentation. And we'll come on to what is fraudulent misrepresentation. At this stage, all I want to say is that it is very likely that if you provide a franchisee with information which is wrong, that it will be treated as fraudulent misrepresentation. And there is nothing you can do to protect you from a claim that you have committed fraudulent misrepresentation. Next, don't put pressure on franchisees. I know, you've been talking to this franchisee for the last 9 months, they're dithering, not knowing whether to go ahead, you're getting cheesed off. You're tempted to say, look, unless you sign up in the next, 2 weeks, I'm going to transfer the offer of the territory to somebody else, or you're going to miss the next induction training and so on. I get all of that, but try to resist that temptation. So I now want to turn to the agreement itself and some guidelines on your franchise agreement. The franchise agreement has two purposes and only two purposes. Number one, it's to protect you from litigation. So in other words, it's drafted in a way that a franchisee's lawyer will say, well, it's not worth bringing a claim. And if you bring a claim, you, the franchisor, bring a claim, it gives you the best chances of success. It shouldn't be too one-sided, and we'll come on to that again by reference to the Drain Doctor case. Now, the purpose of a franchise agreement is not to be nice, okay? It can be tough. And I'm currently working with an absolutely brilliant franchisor that's been Franchisor of the Year at the BFA on numerous occasions, that treats, and I wholly approve of this, its franchisees, in the best possible way. And they asked me to update their franchise agreement, and I produced a franchise agreement that worked. And for the last 6 months, we've been sort of taking out all of the things that they think has an effect on the relationship, because they want this partnership type relationship. However horrid your franchise agreement is, it doesn't affect the relationship. What affects the relationship is how you treat your franchisees. And I've completely failed to persuade them that the agreement needs to protect you. It doesn't need to reflect the relationship. How you enforce the franchise agreement will reflect the relationship. Not to be too one-sided, which I mentioned earlier. We saw that in Drain Doctor. It was horrid. Curiously, however horrid a franchise agreement is, I haven't ever come across a situation where it puts off a prospective franchisee, because prospective franchisees simply don't know what to expect from a franchise agreement. So that they don't know that a 120-page Drain Doctor agreement isn't pretty standard. It can put off a judge, as we saw in the Drain Doctor. So very much have that in mind. Spend money on having the best franchise agreement, because however much money that's going to cost you, it will be tiny in comparison to the cost of litigation. So if you can put yourself in the best possible position to discourage litigation and put you in the driving seat, if unfortunately you do have to litigate, go for it. And next, I would say this, wouldn't I? But keep your franchise agreement updated. You know, you don't have to do it every year, but certainly I would, you know, I'd get your franchise lawyer to give it the once over and update it every 4 years, for instance. And although you're all ahead of this, I always say when giving seminars to prospective franchisors, please use the franchise agreements that you can download for 100 quid on the internet. And the reason for that is I make way more money from franchisors who've done that and who've got themselves into a hell of a lot of trouble than I ever do from drafting franchise agreements. And don't use consultants. And Julia, I really meant to check with you and Ken whether you ever prepare franchise agreements for your clients. And I'm so pleased you said that, because any franchise consultant who prepares franchise agreements simply uses an old standard they got from a lawyer that they used 5 years ago. And lawyers can make a mess of franchise agreements. So I'm sorry, consultants can make and do make an even bigger mess. So be warned about that. Now, have a look at your franchise agreement, if you can face it, after this seminar. I've listed in the notes a few clauses that to avoid. And just to give you a sort of heads up on timing, I'm aiming to finish in 10 minutes, quarter of an hour the most. So if you're enjoying this about as much as root canal work at the dentist, only another 10 minutes, a quarter of an hour to go, okay? So what are the clauses that you need to look at in your franchise agreement that really should not be there? You don't want a clause, which used to be really common, that you will treat all franchisees the same. Because that obliges you to treat all the franchisees the same, and no franchisee is the same. And if you've got that clause and you pick on a franchisee, they will use it and say, look, I'm being picked on, judge, it's in breach of that clause. You need to set out ways to resolve disputes. And I'll come on what needs to be there, but if it's litigation is the only way to resolve disputes, you need to change that, and we'll see how you should change it. Most franchise agreements I see impose a one-way good faith obligation on your franchisees. That is wrong. That is self-evidently wrong. If you expect your franchisee to act in good faith towards you, you need to accept an obligation to act in good faith towards your franchisee. And I think having a one-way good faith obligation is very likely to put off judges. And make sure you don't have too ambitious a restrictive covenant that applies to the whole of the United Kingdom, applies for 3 years, etc., etc. You really need to have a post-termination non-compete covenant that is absolutely clearly enforceable, 12 months in the territory competing business. And the other thing, which is not a contractual term to avoid, is avoid solicitors who think litigation is a good idea. So test them out. if you've got a dispute and you go and see your solicitor and he says, oh yes, we should litigate this, without making any attempt to persuade you there might be a better route, a better way of resolving it, I would be very deeply suspicious. So what are the clauses that you need to have in your franchise agreement? Number one, a clause that says it is not part of your obligations to police the franchise agreements, to enforce the provisions of franchise agreements. It's up to you whether you do or you don't. There needs to be, in my view, a written acknowledgement that the franchisee has read and understood the franchise agreement, and ideally in a written acknowledgement that they've obtained independent legal advice. And you encourage that by having perhaps a panel of franchise lawyers that you would recommend. Now, there are some franchise lawyers who charge a lot of money and don't give terribly helpful advice, and there are others who do. If anybody here wants my views, and I've got to be really careful how I express them, I'd be delighted to give them. I mean, really what franchisees want, they absolutely don't want lawyers that try to amend the franchise agreement. What they really want are lawyers that highlight those provisions in the franchise agreement, your franchise agreement, which are unusual, onerous, or unworkable. That's all that a franchise lawyer should do. You would have a clause, a detailed clause, saying that you've made no misrepresentations. A thing that I'm really keen on is a clause that says, you, franchisee, if you want to bring a claim, you must do it within 12 months of becoming aware of the situation. And that would discourage lots of claims which arise, way down the line on a termination and so on. You also want a clause that says if you are successful in litigation, you get your costs on what's called an indemnity basis, all of your costs back, and not costs that are limited. You would have a mediation clause. I am a huge fan of mediation. It's a really good way. There's a lot of misunderstanding about mediation. You're never obliged to settle on the lines of what the mediator wants. You only settle if you want. So your dispute resolution clause should say the parties will try to resolve matters amicably first. Secondly, they will refer it to mediation, and only thirdly to litigation. You have a clause where all customer data belongs to you, okay? And ideally a clause that says that they have to provide that customer data to you every month or electronic, make it available to you. Restrictive covenants, blue pencil tests, I won't talk about, it's just legal stuff. Make sure that there are provisions where franchisees have to report to you all of the stuff you need to know, and even more importantly, that somebody looks at it and somebody actually requires enforcement of those reporting obligations, and I'll come back to that in a minute or two. Put in a clause that says if you are in breach, we can serve a breach notice, and for a breach notice, you will pay us £250, £100, £500, whatever the figure is, because a franchisor I was preparing a franchise agreement said to me, John, your franchise agreement is completely useless. The only thing I can do when a franchisee is in breach is terminate. Well, that's a nuclear option, but I may not want to terminate. He or she may be a really good franchisee that's just messing me around. And so it's really good to have this breach notice provision, which I don't actually see terribly often in a franchise agreement. For retail franchises, you want an option to take over their premises, and probably on termination, an option to take over their business, as well as an obligation to transfer email addresses, telephone numbers, and so on. So those are the steps you need to take on the notes, there's a bit about misrepresentation, but it's boring. You don't need to know about it. Franchisees will always claim that you misrepresented the position, and the only way to protect yourself is to tell the truth. Now, who is responsible for your franchise agreements in your organization? Let me tell you, in my experience, the responsibility for franchise agreements, which means for monitoring performance, for ensuring they're executed right, is almost always passed down to either the most junior person or the person that everybody hates the most, because it's not viewed as terribly important. And I'm really sorry if you're one of the people that has been given the task to make sure franchise agreements are executed properly. I'm sure everybody loves you. Okay, no, seriously, everybody loves you. In my experience, about 40 to 50% of franchise agreements are not executed properly. And that can cause you huge problems when it comes to litigation or a dispute, because it enables a franchisee to say, no, you can't enforce it. You didn't get me to sign, or whatever it is. So make sure that's done. Either use your solicitors or make sure somebody or you have a note from your solicitors as to exactly what needs to be done, and make sure that it's done properly. Ideally, monitor the obligations. So get your lawyer to produce a list of what it is that the franchisee must do, what information the franchisee must provide to you. Too often I get franchisors saying, oh, can I get this financial information from a franchisee and go in without an announcement to the premises and download it? Well, the reaction I ought to give is, read your effing franchise agreement. It's in there. They're supposed to provide this information. You've got the right to go in without notice. But obviously, I'm a lot more polite and say, well, look, I better look at your franchise agreement. So be very clear about what rights you've got and what obligations the franchisee has, and make sure you enforce it. And don't ignore those obligations. Also, treat franchisees with respect. There's some research in Australia which shows that the thing that really pisses off a franchisee, forgive my language, cheeses off a franchisee, is lack of respect from the franchisor. Communicate really often, innovate a lot, and that includes with marketing and so on. A thing that really also irritates a long-term franchisee really experiences a BDM, or whatever title you give to your regional guys that visit franchisees, recently recruited, knows absolutely nothing about the business, trying to tell somebody who's been in the business for 15 years what to do. I mean, it's bound to irritate. If a franchisee is in breach, it doesn't legally entitle you to counter breach, so don't do that. And establish a paper trail. Franchisee is doing bad things. You start off with a letter saying, we notice you're not doing this, can we help? And it's help, assistance. Look, this is serious, you've got to take it seriously. You know, we really don't want to terminate. Look, we're going to terminate, and so on. So that you don't want to launch too quickly into a termination without a paper trail. There are some other elements on the notes which I think I won't include, but other than to repeat that if you bring a simple claim, it's bound to get complicated because a franchisee is bound to counterclaim. And because a franchisee is bound to counterclaim, on a termination, you terminate, you can take over their business if your franchise agreement says you can, and you can claim damages. They're bound to contest that. So you do need to think of ways to avoid that by way of a settlement, in which ideally the franchisee would say, yes, I agree you've got the right to terminate, but in return for you giving me 6-12 months to find a purchaser for my business, I acknowledge you've got that right, and then I can find a purchaser. The advantage of that is a franchisee ends up with something as opposed to nothing and has the wherewithal to pay you damages. If unfortunately you go into litigation, be nice, show compassion to a franchisee, comply strictly, however irritating this little so-and-so was, however much of a pain in the arse, and how delighted you are you finally got rid of them. Comply strictly with the terms of the agreement. Now, if after all of that you end up litigating a dispute, I'm really sorry, and I suspect it would be the subject of another webinar organised by the franchise company about what you should do if you are in litigation. But I doubt, Julie, that anybody who has listened to this could face another seminar on the subject, not for at least another 5 years. Thank you very much for listening.
Thank you, John. Virtual claps. So, John, we do have some questions that have been put in the box.
Can I ever take you in there?
I think during the event, I've virtually put everyone on mute, but if people obviously want to come off mute now,
Right.
feel free. Or if you want to ask a question, you can ask a question.
Yeah. Because now he's managed to get that back area back into a habitable space, a bedroom. I reckon, Bob and I looked at it with Polly, we reckon we could get a nice little
Julie, can I ask a quick question? It's Ken, John. One, in terms of fees, which I guess from experience tends to crop up from time to time. One of our clients has successfully used the county court judgments to recover outstanding fees. Is that something that you would maybe suggest or have much experience of?
Indeed. I mean, the county court is, there are advantages and disadvantages of the county court. Number one, it's cheaper. Number two, and this is a disadvantage, so the judges are less good than the High Court. And if your claim as a franchisor becomes a misrepresentation claim, the county court isn't really ideal for that. So yes, of course, everybody's solicitor should look at the county court as an alternative. Yeah.
Okay, thank you, Ken. There were a couple of points, John, I was just going to make, obviously, because there's the people on the call who clients of ours. Most of you will know that John and I have worked very closely together, despite John on several occasions trying to get rid of us, but we have worked very closely together for a number of years, a lot of years. And basically, John's obviously the legal, we do things from an operational point of view. So to add to all of the fabulous points that John has made, from an operational point of view, we're very much about recruitment and recruiting franchisees. And, on many occasions, people come to me and say, can you help us to sell franchises? And my answer is always, no, we can't, because we don't do that, because we don't advise that you do that. But by following a process of recruitment, hopefully, the individuals that you are potentially going to bring into the business become a position where they are, in effect, fully informed, and therefore able to make an informed judgment and decision about the franchise. And the methodology that you use enables them to achieve that, but it also gives you that evidence and paper trail, whatever, that you've taken them through that process. So that was my first point. And my second point, in terms of the agreement, and again, John, you made a really good point about when you share that agreement with the potential franchisee, the perception is that no one's ever going to sign that. And again, my experience is very similar to John's, that actually, most franchisees read it, hopefully they understand it or it's explained to them. But generally, if you want good franchisees, are happy to take on board. And the point again that we always make is that that agreement is actually there to protect franchisees from other franchisees within the network doing things wrong. Because if a neighbouring franchisee starts to damage the brand, book the system, whatever, the franchisee individually has no direct legal relationship with that neighbouring franchisee, and actually they have to rely on the franchise agreement to enable the franchisor to protect their business. And again, in terms of methodology, my approach is to always say, you know, if you're intending to join us because you want to follow our system, then that you're the type of franchisee that we want to have. And this is going to protect you from the event that a franchisee doesn't follow the system. Does that sound like a particularly, you know, good idea from your point of view? And most people will agree, and if they don't, you probably don't want them anyway. So that was my kind of 2 points. And my final point really, and again, this is about really the working relationship that you have with your lawyer. You know, again, we have long-term working relationships with clients, and quite often they'll come back and say, we've got this problem, and go through it. And my response to that is always to, if it's very early days, maybe to talk through it with them, give them some, you know, counselling advice, whatever, but actually at a very early stage to say, go and talk to your lawyer, go and talk to John, pick the telephone up and have a discussion. Because if you do that in an early stage, it will generally save you a lot of time and heartache and money in the future. And again, the experiences if people don't do that and they just let things run and run and run, that's when big problems can develop, subject to the type of lawyer that you're working with, basically. Anything you'd like to add to any of those points, John?
No, other than say, as always, very good points.
Good.
John, can I ask you a question? So I've had the privilege of knowing you over 20 years, and I never tire from hearing from you. So thank you very much indeed. But look, I've spent the last 20 odd years in franchising, always believing that legislation was the wrong thing for the industry. But my question now is, you know, if we had legislation in the UK, franchising legislation, that would go some way, presumably, to mitigating this hierarchy of ignorance within the judiciary about franchising. Because one thing is clear, the Drain Doctor case clearly demonstrates, and I hope it gets appealed, because it's awful. It really is awful. The decision the judge has made is based on a lot of emotive and subjective information rather than hard facts, and actually understanding the relationship between franchisor, and also there's no regard for know-how, for franchising know-how, which is at the core of anything. So my question is this now, is the time right to debate legislation in the UK for franchising, i.e. standard format disclosure legislation? Would that ensure a more successful route for franchisors that go through litigation, and ensure that there is parity between judges when they're making these decisions?
Well, I mean, Simon, yeah, I suspect we've known each other for way longer than 20 years. But anyway, although you hardly look old enough. There's a big debate. The BFA, and I have to say I'm completely on the side of the BFA, is dead against regulation of franchising. US lawyers, most heavily regulated country in terms of franchising, describe their legislation as Franchise Lawyers (brackets Full Employment) (end brackets) Act. And it's be great news for lawyers. We charge loads of dosh for doing a disclosure document. And the problem I have with legislation, is that what happens in America is that franchisors think, well, providing I comply with the legislation, I can be as bad and as horrid as I want. And so it doesn't actually encourage good behavior. And I believe that actually franchising in this country is the most ethical than anywhere in the world. And we're one of the very few countries that doesn't have franchise legislation. So because of that, I personally am not in favor, and I don't think, Simon, it would solve the problems.
Okay, no, I actually do agree with you, but equally, if one took at face value this judgment of Drain Doctor, you'd be quite worried as a franchisor. You know, I'm assuming that the franchisee was a sole trader here, which, I mean, if they were a limited company, there wouldn't be such emotion around the loss of the business, would there? You know, if it was a business-to-business relationship rather than a relationship between a multinational global franchise and Mr. whatever his name was. Is that one way of taking out some of that subjectivity and emotion from these decisions?
Well, actually, the franchisee did operate through a limited company, Simon.
Oh, okay.
So I don't think it makes that much difference, in fact.
Okay, excellent. And just sorry, I never give up an opportunity to get an audience with John Pratt, so I do apologise. But would it make sense when you're having a litigation for the first? I mean, presumably you can call expert witnesses, can't you, in these hearings? Isn't the first witness that you put on the stand is a franchising expert, i.e., somebody from the BFA that would say this is what franchising is all about? Explain the know-how and explain the relationship between franchisor franchisee and put it into context from the very start of the hearing.
I think that, do you know, Simon, I think that is a really good point. And it's never been done that way.
No.
But it should be. You're right. Thank you.
Yeah. Bless you, John. Thank you. Thank you very much.
John, I had another question about the drain doctor kind of case, which was basically, did the individual have any previous experience in the sector, i.e. had he been employed as a drain cleaner prior to coming into the business? No. And let's face it, that's pretty standard in franchising. You tend not to pick franchisees who've been involved in the sector. Yeah, but obviously in things like hairdressers, it can be an issue if the person who's the franchisee was previously a hairdresser. Indeed. Yeah. No, there are exceptions. Quite right. Yeah. Right. Okay. That's great. And I think there were a few more calls, a few more questions. And just while I'm skimming through the questions, I would just like to raise the point that I've put in that Chris Wotton, who's on the call, who's a full member British Franchise Association franchisor, is standing for the BFA board. And although he's not allowed to, as it were, tout for any votes on his behalf, I am allowed to ask for anyone who's also a full BFA member who hasn't yet voted to consider voting for Chris, who's a former franchisee and now franchisor, the Poppies. And in my opinion, would do a tremendous job. Thank you. And there is another question, actually, it was another one of mine, John, which was this, again, going back to the drain doctor scenario, which was actually the impact, if you like, not only had the company, the franchisor, lost to the case, but to some degree, so had the lawyers, in terms of if it was deemed to be that their franchise agreement, which they drafted, didn't stand up in court, then presumably that's a negative effect for them in terms of potentially the franchise agreements they've drafted. So I guess to some degree, is that potentially also driving the situation to actually go back and appeal it? Well, interestingly, in the drain doctor case, the law firm that drafted the agreement was not the law firm that did the litigation. All right. So yeah, they can say, well, it's not our agreement. Okay. Thank you. Rick has raised a point about, is it time for the UK to take a long, hard look at franchising in Australia? Rick's got a comment of masses of paperwork, but worth it. Well, you know, I mean, I take a completely different view to Rick on that. The most dodgy, aggressive, nasty franchisors, I hope nobody here is an Australian, franchisors I ever come across are Australian. And yeah, of course they've had to regulate what those horrible Australian franchisors do. There are some nice ones. But, you know, I think they're still up to no good, even with the regulation. So I just think, you know, to repeat the point I made to Simon, we are much more ethical here than, in my view, than anywhere else. Okay. And he's also put another point, which is when franchisees understand that breaching their agreement is breaking the law, we're in with a chance, aren't we? This was Rick's point. Whilst you were talking, I was reading to somebody saying, sending me a very nice little note. Sorry, Julie, what, can you repeat that? It happens hardly ever. So, you know, I was taken away. It is Friday, John, so, you know, it's allowed. Rick said, when franchisees understand that breaching their agreement is breaking the law, we're in with a chance, aren't we? Well, yes. I mean, breaching of franchise agreement is
gives rise to a contractual claim, it may not be a breach of the law, but yes, I mean, you want to be careful how you treat franchisees. If you're constantly telling your franchisees, if you do this, we're going to sue you, or it's infringes our contractual rights.
Yeah.
I'm not convinced that that's a good strategy.
I think it possibly maybe comes back to the point of being able to demonstrate either that your franchisees did take legal advice.
Oh, okay.
They were advised to take legal advice, and on the basis that they took it, hopefully, as a result of that, they actually understand what's in the document.
Okay. Julie, look, have a bit of concern for the poor people that are still on this. They're dying to get off this call, but they think it's a bit rude to sort of click off.
Okay. Good point, well made. So, well, if anyone else has got to, would anyone like to come off? Has anyone's got any final thoughts, comments, questions? As many have said, this is the chance to ask John Pratt a question for free and keep him on this call for as long as you wish to do so, basically. But otherwise, this is our final first Friday before Christmas. So I think it comes down to me to wish everyone hopefully a happy Christmas holiday, and we're all looking forward to a good 2022. And we will be back in 2022 with another 3 events in the first quarter of the first Friday. And obviously everyone that's been on the calls, any calls we've been on so far, will be informed of those within the next few weeks. So
I had one quick question to John.
Yeah.
Could you tell me what the executive marketing territory was in that case, and how far it extended?
How far the
Because it says that they didn't go ahead, right? So the region or the covenant that prevents them operating, the non-compete, right? In this case, I guess it wasn't. It didn't apply, right? So,
well, it did apply. What the covenant said is you won't be involved in a competing or similar business in the territory, used a different term, and in a radius of 5 miles from the territory. 5 miles from the territory was never going to be enforced. In the territory, it should have been enforced, but the judge found things wrong, other things wrong, with the geographical extent with the covenants, and so found against the covenants because there was some drafting that the judge didn't like.
okay, so assuming that the territory was a part of London or part of whatever the city was, that's why it was enforceable, and if it was a larger territory, then it wouldn't have been enforceable. Is that how it works, or? No.
A territory really has to be linked to where the franchisee's customers are. Mm-hmm. And so a franchisee operating in Northumberland mm-hmm. Will have a much bigger territory than a franchisee operating in central London. So you do need to give some thought to the size of the territory, however you describe it, in your franchise agreement. Okay. For each individual and each location.
Right. Okay, thanks.
And again, just a final point, there are methodologies to do that, and there are some specialist companies, again, BFA affiliates, who actually, that's all they do. They do territory analysis and territory mapping, which hopefully should help with that. So, great. Thank you very much, John.
It's a pleasure. Thank you for listening, and have a good Christmas. Okay.
Take care. Bye, everyone.
Bye.
Cheers. Bye-bye. Bye-bye.
Thank you.